I'd like to begin by thanking you for taking the time to interview with the Cambridge Journal of Law, Politics, and Art to discuss your incredibly influential career as a prosecutor, both in your native Argentina and subsequently as the first prosecutor of the International Criminal Court. In Argentina, during the democratic transition, you played an instrumental role in holding senior military commanders responsible for human rights violations. And then at the ICC, you opened investigations into numerous alleged international crimes and oversaw the first complete trial at the court. Since then, your continued work on the issues of international justice and accountability have been crucial as the field of international criminal law evolves to meet the challenges of our time. So I'd like to start by just turning the floor over to you. And I think that there was something that you wanted to discuss and turn our readers' attention towards.
No, I really appreciate this conversation because I believe I never studied international law or international relations in the university. I learned by doing, by practice. But after I finished my ICC tenure, I was studying and teaching at Yale, Harvard, Hebrew University, at Cooper University, and I'm shocked that I received a legal mandate, but no academic discipline is covering it. So that's why people like you who are concerned about human rights believe, oh, this something would happen because it's prohibited, it's a crime, stop it. But then people start international relations, say, you don't understand, law is utopia. No, it's about power. The world is in anarchy and you need armies to protect yourself. So if you are in Finland, suddenly you start to buy weapons to protect yourself. Even the Green Party became supporting the idea to buy weapons. So suddenly the Russia invasion, illegal aggression against Ukraine triggered that the only valid paradigm is war. And that made me feel, oh my God, how to present this properly. That's why I'm very glad that you call me and have this conversation, because it will be your challenge, how to present what I'm saying in a way your readers follow. But let me give you an example. This morning, I had a call from Armenia discussing how can I help them, if I can produce a report for them on what happened today in Artsakh. Artsakh is an Armenian region inside Azerbaijan. The only way to get food and medicines and oil is through a road that connects Armenia with Artsakh. There is an international treaty signed by Armenia, Azerbaijan, and Russia saying this corridor to be open, had to be open to continue Armenia helping the Armenians in Azerbaijan. However, in June this year, so a month and a half ago, Azerbaijan closed the road using different arguments. And that's basically a genocide is happening today against Armenians. It's not 100 years ago, Armenian genocide. It's today. And because we are so segmented that the journal has no space for this because it's still coming, there's no blood, it's just genocide by starvation. And so it's not clear. For political interest, the interest is in Ukraine. Azerbaijan is helping Israel and the US in dealing with Iran, so no one wants to touch it. Russia, with a role, is discussing with Azerbaijan exporting of oil. So that's why economic and political interests are on the side of Azerbaijan. And therefore, no one is talking about that, even talking about that. So, and that is for me the problem. Without clear rules, how to, and the rules is not just about court rulings, because when the case arrived to the court, yes, it's very clear. There's no power problem. The judge has the power. But before that, you need states preventing the conflict or against the crimes. And that is not always easy. It's always complicated. And that was my experience. So for me, the idea is be a prosecutor is like a cook. You have to combine the food to produce a good meal. And when I went to Harvard, I was thinking, okay, now I will learn to more how to cook, but not. In the universities, they segment the story, and there's no teaching on how to cook. It's a teaching about what the potato is. That's the problem. And when you are dealing with this conflict, imagine today Armenia or Ukraine. It's about crimes, it's about law, it's about facts, it's about perpetrators, about responsibility, it's about political interest, it's about economic interest, it's about media, it's about so many different things that you have to combine. And that combination, no one is teaching about it. And professors select little pieces because, of course, are important. You have to understand the law, or you have to understand the power, but the combination is the point. That makes me the main idea I like to pass to you. Okay, that's also the main idea in my book. I don't know how, the problem is, it's easy to ignore because my practice is not fit exactly neither in international law, international criminal law, nor international relations. So that's why, or you can ignore it, or you can, oh my God, it's so political. Oh my God, it's so legalistic. Oh my God, it's so utopian. Oh my God. So whatever, ignoring the complexity.
I'm really interested by this idea of segmentation that you're referring to. And I'm wondering, with your experience both in practice at the ICC and elsewhere, in addition to your thought on politics, geopolitics, international relations, how can we begin to marry those things past just the conversation piece that you mentioned? Are there institutional ways that we can go about incorporating all of these things together? What are your thoughts on that?
Well, my feeling is we need to do case studies. So case studies allow you to combine what we call different academic fields. I don't think we can do a theory on international criminal court, but we can do a case study helping us to connect the problems, not to study them in isolation. That's my suggestion. That's why my book is a case study about my practice. It's connecting the different dimensions. Stephen Krasner is currently the Dean of International Relations School at Stanford. He's one of the biggest professors on this topic. It's very smart and very candid. And we became friends because I was teaching there 20 years ago. And after I left ICC, he told me, Luis, I don't understand what you say because law is not part of my discipline. We focus on power. And I say, Stephen, you have a problem because you are missing that law creates power. When the state parties appointed me as a prosecutor, they gave me an enormous power. I can indict head of states. Imagine. It's not because me, it's a function of the prosecutor. It's nothing personal. It's the law creating power. So you have a problem. If you want to understand power in the 21st century, you have to understand law. You have a problem. He say, no, Luis, you have a problem. Law is not part of my discipline. That's it. And it's happy, the professors are happy to keep the boundaries very strongly. Another friend of mine was commissioned by Oxford University to write a book about the ICC. So he interviewed me many times. He's a young professor. We became friends because he was interviewing me so many times. And then when we finished the book, he asked my opinion. And I said, look, I love your book because chapter 1, chapter 2, you describe very accurately the facts, describing how things were changing. But what's shocking for me that the conclusions are nothing changed. So your chapters change, not change the conclusion. So what is the relationship between your conclusion and your book? You know what he said? He said, Luis, I need a tenure. And that's the point. He understood the members of the jury will evaluate his book according with their own thinking. And they are all people like me, so they don't like change. So basically, he understood and he got the tenure. he got the tenure. So, and that's why I feel what I found is the academics, the scholars talk between them, trying to protect their boundaries without crossing the boundaries. And if you're a young scholar trying to make interdisciplinary analysis, you are dead. No one will promote you because the different discipline will say, no, you are not part of us. So to escape that, I think we need to do case studies to understand and learn. Because for me, and that's probably the last topic of my introduction to our conversation, is the real thing is we cannot say it's just law. We cannot say it's just power. We have to understand the interaction between them. And so the issue is not which will prevail. The issue is how to harmonize them. That is, for me, what is needed. And through case studies, and that's what I try to do with my book, we learn when in some cases there were efforts harmonized, and in some cases was not possible. So that is for me what we learn is case studies and trying to understand who are decision makers, how they interact, and how we can harmonize.
Do you feel that practitioners of international criminal law, judges, lawyers, and also political leaders around the world, do you feel that they understand this interdisciplinary aspect of law, politics, power, or do you feel like the practitioners and the political actors are also not acknowledging these?
Well, I feel I have a course because the only job that required to combine these different dimensions is the prosecutor. Because if you're a judge, you don't need to discuss power. When you're the judge, you have all the power to make decisions. And the rules are clear. Of course, the problem is when you issue a arrest warrant, then you expect the state following your instruction, and they don't. As soon the problem leave the courtroom, the judges lose their control. But because they are, and so for them it's difficult to interact with the political people. And the political people, there is no global political leader. So American leaders will represent American voters. French leaders will represent French voters. Russian leaders will represent Russian people. So that each people, none of them need to integrate information. They just follow their own national interests. And that, Koskinyemi said very rightly, international law is whatever the state decides to define as international law, because each state is following its own prerogatives. The funny thing, the existence of the ICC transformed the game because the prosecutor is an impartial actor, not follow national agendas, and crossing and forcing the other countries to act. That is the beauty of this. But my frustration is that ICC is like a first model. And we can keep evolving. We can even use the idea of ICC in climate change. Because for me, ICC, beyond the criminal part, is a new idea combining national states with rules and one independent enforcement mechanism to implement the rules. That is the beauty of the design that could be applied to climate change or global pandemics or other global problems or international terrorism. But we are missing that part. We are missing that part. And then we need to keep, that's why your generation, I love this conversation because your generation should be in charge, but they have to understand it's not about insisting on international law or just insisting in power. No, how things combine. For me, the example I use in the book is imagine a traffic light with red light and green light on at the same time. It's not about understanding red you stop, green you go. No, what I do when I have both at the same time. So how to harmonize that? That is for me the challenge of your generation.
Following up from what you're talking about in the respect of requiring the harmony between the international law and the power, but then equally it's a matter of each state responding to and what they accept to be the international law. And as you said, the ICC is the beauty of bringing all these states together and having the potential to be more than what it currently is. But how do you see it going the next step forward for the next generation? Because a lot of it is a matter of getting the states to respect the ICC, but then also to enforce it and getting states to sign to it. So how do we continue with that implementation of having that respect for the authority for it?
We need new ideas. In my time, I saw how a young group of people, invisible children, using what was a new technology in those days, YouTube, produced a documentary called Connie 2012 that became viral. In 6 days, they reached 120 million viewers. And they combined this pressure from young people from all over the world with, they were working in the meantime with the US government, African Union, Uganda, and then they combined, and basically this combination really ended the crimes committed by Joseph Kony in northern Uganda and Central African Republic. So that is a good example. How to do it that, okay, now we have more, that's the funny thing. ICC, in 2003, I was teaching at Harvard. I left Harvard to go to ICC. In 2003, Zuckerberg left Harvard to create Facebook, okay? Both Facebook and ICC reach 100 million people because ICC involving 121 states, protecting more than, I think it's 2.3 billion people. But after Facebook, you have a Instagram, you have a TikTok, you have a Twitter, you have many other applications, many other events. And ICC, no, it's there. And even the professors are, instead to keep thinking how to improve ICC or how to innovate in other areas, they are ignoring or attacking ICC. So that is for me the problem. We don't have thinkers evolving, moving beyond national states, understanding we need cities, we need national states, but we need something bigger for some problems, not for all the problems. And we have to distinguish that. Massive rapes of women, massive killing of women is a global issue. Marrying 4 women against Muslim countries is not so global, it's more a national debate. So we have to distinguish between problems which are national or local and problems that are global. And genocide, crimes against humanity, war crimes are clearly global problems. Climate change is a global problem. Pandemic is a global problem. So we have to think on that new problems in a new way, beyond national states.
Just to your time as the ICC prosecutor, we're interested in during your time, you had to work with the Security Council, whether it was through referral of a situation by the Security Council to you, or alternatively suspending an ICC investigation or prosecution. In light of the different political agendas and alliances of the members in the Security Council, especially considering the veto, how does the ICC ensure that the crimes pursuant to the Rome Statute are investigated when they need to be?
ICC cannot do that because the jurisdictional decisions are taken by states. So that's very important to distinguish responsibility. The state parties accepted that intervention, and then the prosecutor is responsible. But the non-state parties, who are 72, including the biggest countries, they don't accept it, so it's their decision, or the Security Council decision. So what you expect ensuring justice is not a matter of judges, it's a matter of politicians.
Following from that, do you feel that there are any institutional or mechanistic changes that can be made to increase access to justice? If we're at the mercy of politicians,
we need new tools. Example, because the national state system is based on representation, no? Representative democracies. People choose, people vote, elect representatives, and they take decisions. But if you are in Artsakh and you're a victim of the current genocide, you are not represented in Azerbaijan, and you are not represented in Israel or in US. So basically, these people have no representation. Therefore, maybe we should invent some artificial intelligence connecting the victims of Artsakh with American people, British people, people in different countries, and they can influence their own representatives, transforming what was a global, international issue into a national issue. So that what happened with Congress 2012. They were able to transform a remote conflict in Uganda into an issue that the US Congress was involved in. So that type of connections, helping, and young people could do that. Young people who help victims who are underrepresented to be represented in different forums. No? That could be one solution. In my experience, I saw all the possibilities. France, for instance, when they managed to get a UN Security Council referral in a time that was impossible, and they got it. How France forced the US to accept their full referral is fascinating, because that shows the possibilities.
Continuing from your answer and to the different avenues of possibilities, I wanted to ask about your opinion about the use case of universal jurisdiction. Do you think using universal jurisdiction from state parties may be more of an appropriate and realistic legal avenue to establishing accountability and serving justice for the victims, seeing as there is less of a political hurdles to overcome as you would in the ICC spotlight? Hear about Syria. For instance, we just had a discussion with a Syrian lawyer, Alwa Boni, and he tried for the war crimes that occurred in Syria in Germany, and they did it on the basis of universal jurisdiction. Germany is one of the many countries that is quite moving forward with universal jurisdiction. But do you think there's avenue for this to be used more often, because it is a concept that many state parties recognize, but it's underused.
That in the case you mentioned, the person indicted was in Germany, and that provides Germany jurisdiction. So, and they indict this individual. I have nothing against that, but that will change nothing in Syria. So, because me, the role of the criminal investigation, when you are dealing with organized crime or massive crimes, you have to disrupt the organization committing the crime. And that's why, for me, focus on the most responsible was the idea. So if you indict Assad, that's different than if you indict a former member of Assad intelligence who is in asylum or living in Germany. It's fine, but it's no change for the real situation. And that is typical lawyer's attitude. We believe it's about the number of criminal cases. No, criminal case is an instrument to prevent crimes. So we should not believe, oh, it's okay if we're doing this in our cases, in our countries. It's nothing against, but that's my main answer. In addition to that, if the national judges are not equipped to investigate crimes outside, and it's complicated for them to do it, and normally could be political bias, because, for instance, France indict a member of the Rwanda government, the Tutsi government, as a retaliation for some tension France has with Rwanda today. So could be another political tool. And I think it's important justice remain impartial. So my answer is a little longer, but I believe universal jurisdiction is okay, but could not replace a real justice system focusing on the more responsible, focusing on the leaders, because basically these crimes are committed by organizations following leader instructions. So if you like to stop the crime, you should really focus on the leaders. That's it.
So related to this topic, I think we can discuss a little bit about the Russia and Ukraine situation. So the ICC has issued an arrest warrant for Vladimir Putin. There are conversations about creating a special tribunal to try Russia on the charge of aggression. I'm wondering what your feelings are on these avenues. Do you feel similarly to your answer just now on the universal jurisdiction case, where these aren't the kind of things that will make a legitimate difference on the ground? Or do you feel like these are appropriate avenues that may provide some relief?
The aggression in Ukraine is affecting has two dimensions. One is affecting the Ukraine territory integrity, but also it's affecting how will be global order. On the integrity of the territory, it's clear, should be rejected. Ukraine integrity has to be respected. The second topic is very important, because the second topic is, okay, global order will be based on power or will be based on law. And the Ukrainian intervention exposed that the jurisdiction on aggression by the SEC was flawed. So the states impose an extra requisite. Normally, the jurisdiction of the SEC required that the crime was committed in the territory of state party, or a party that accepts jurisdiction. In the aggression crime, they added five words, asking, in addition, the aggressor should also be state party. That is establishing impunity by design, no? Because of course, the biggest countries, US, Russia, China, will never be part of the ICC, and therefore they can invade any country in the world, nothing will happen to them. And that should be fixed. So Ukrainian conflict is an opportunity to fix that. The easy fix, delete these 5 words. And the only requisite is, as in normal crimes, the territory of a state party or accepting the jurisdiction of state. However, the US pushing and the European Union voted the idea, oh, to fix that we have to invent a special tribunal. Could be a special tribunal against Russia, not against America or against England. So that is consecrating impunity, is going back in the time, because the biggest debate at Rome in 1988 was justice will be independent for everyone, or justice will be in the hands of the Security Council members. And therefore, this proposal of the UN Special Tribunal is going back justice, selective justice, in the hands of the Security Council people. In the meantime, what is fascinating for me and transforming the debate is the ICC issue a warrant already on war crimes. Yes, it's not about aggression crime, but it's a war crime. And it's a very beautiful case because it's small, clear, Putin was involved personally, and you have a footage to show the crime. So I think the prosecutor is almost ready to go to court. Beautiful. And that's enough, because it's an indictment. You know who Al Capone was? You know who Al Capone was? Al Capone was involved famously in the Chicago massacre. People killed. The prosecutor never found the evidence to prosecute Al Capone for that, but he was prosecuted for tax evasion and went to jail, and his empire destroyed. So you don't need, it's lovely to have a case exposing all the criminality, but when you're a prosecutor, you're limited. You have the evidence and the jurisdiction, and that's it.
And following up on what you've just mentioned, I think specifically it's quite interesting about the crime of aggression and this debate that's been going on about leading practitioners about this. Because as you said, you are against the special tribunal. For you, it's more of just a matter of changing how the crime of aggression is set out as it is now. I was wondering if you could share a bit more of why there's so much focus on trying to get Russia and Putin on the war of aggression when there, as you've said, has already been an indictment from war crimes. Do you think it's a matter of there not being enough evidence to bring him before the ICC, or why is there this focus from the international community instead of looking into the other legal avenues available under the Rome Statute?
Some lawyers, American lawyers feel this way. For American lawyers, ICC will never be part of the US agenda, so the only pragmatic solution is go to the special tribunal. And okay. I'm sorry, but European leaders are soft, are not taking their own position. So, but basically, this is consecrating selective justice. No, at Nuremberg, we had no option. We had to do victor justice. But everyone is against victor justice. And so we cannot adopt as a normal system selective justice, saying, okay, if Putin invade the country, we do a tribunal for Putin. But if we decide to invade Kosovo or Iraq or whatever, that's fine. No, we need similar rules. The US need clear rules also. But that's a funny thing. I don't know why. But it's very, all my American friends are going for the special tribunal. And I say, guys, you understand, you are establishing privilege. Okay, Luis, the only thing we can do. So they believe they are pragmatic. No, they are giving up. They're giving up.